Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. I've received some feedback regarding the lay witness exhibit lists that are coming up due in Idaho versus Kohberger. However, the public will not be privy to what those exhibit lists say. The names of the lay witnesses. These are witnesses with first-hand knowledge. These are not the expert witnesses both sides have proposed. That is in accordance with a section of the October 9th, 2024 pretrial and trial order. There is another section entirely dealing with disclosures and deadlines for expert witnesses. Lay witnesses, unlike expert witnesses, have actual first-hand knowledge that whoever is presenting those lay witnesses as witnesses to testify and to provide evidence at the future trial of this case have relevant information to either the state's case or the defendant's case. Now, unfortunately, in my opinion, the exhibit lists have been ordered to be filed under seal. In this case, where so many things have been filed under seal and remain under seal, because that's how the state and the defense wanted it. It was both parties who went to the court at the very beginning of the case, days after Mr. Kohberger was arrested, and filed a stipulation asking the court to enter a non-dissemination order, aka a gag order, which the court did. And there have been a couple of amendments to that non-dissemination order, but it remains in effect. Neither of the parties have ever gone to the court and asked to have that non-dissemination order set aside. The parties have also, either unilaterally or together, filed multiple documents under seal. In some cases, when it's done together, it's done by stipulation, just like how the non-dissemination order was requested. And again, none of the parties have moved to have any of the discovery requests or responses that were filed under seal and that continue to remain filed under seal dating back to the beginning of the case opened for public consideration. It was the court who directed recently that less items should be filed under seal, and where we have seen finally, after more than 2 years of the inception of this case, certain things like photographs, official photographs, not speculation of what it is, but official photographs of suspect vehicle 1. They were released for the first time by the state and the defense in their Limine briefings of March 2025, along with other items. The witness lists, as we know from the pretrial and trial order, are coming due. They will be filed under seal. There is, however, a way in which the public may learn who these lay witnesses are if they reside out of state. Because what the parties will need to do, if they are calling an out-of-state lay witness to the stand, they're going to have to domesticate the trial order subpoenaing them to provide testimony in whatever state those parties or party lives in. For example, we saw that back when the defense wanted to call one of the surviving roommates to the stand for the preliminary hearing, that the defense had to domesticate that request, that subpoena, in the state where the surviving roommate was then currently residing. And that's when it became public. By way of background, the preliminary hearing never happened because the indictment was issued by grand jury charging Mr. Kohberger with the 5 first-degree felonies he will be standing trial on. And it's always must be mentioned that he is considered innocent under the eyes of the law as to all of these charges until or unless he, number 1, pleads guilty or is adjudicated guilty at trial. So let's take, for example, what happened last week at the April 9th, 2025 hearing on one of the in limine motions, and in one of the in limine motions filed by the state indicating that they may call Mr. Kohberger's family member or members to the stand as a state witness at the future trial of this case. It was brought up also during oral arguments that occurred before Judge Stephen J. Hippler, where it was stated by defense counsel that the Kohberger family has no interest in assisting the state, that if the state wished to subpoena them for trial, they would have to go ahead and subpoena them. They would have to pay for travel expenses and other matters. So, therefore, in the event that the state does proceed with issuing their trial subpoenas for lay witnesses in Pennsylvania, such as the Kohberger family, we can expect to see some sort of a case being opened in the Commonwealth of Pennsylvania, similar to what happened when the surviving roommate was subpoenaed for the preliminary hearing that didn't happen. A case had to be filed in the state where she resided, and that's when matters went public. So we will continue to monitor the docket and advise you when the lay witness lists are filed under seal, and we will continue to monitor the situation if we see any actions by either party, by the state or the defense, when it comes time for them to subpoena their trial witnesses to see if any out-of-state cases are opened up to domesticate, thereby making a request from another state, a subpoena from another state, effective in the state where the lay witnesses reside. Until next time, this is Kathy. Thank you for joining us here today.